of Rivers State, Simeon Fubara, has said that the House of Assembly does not exist and that he doesn't recognize the members who defected from the PDP to APC. And spokespersons for his position have said, Section 109 of the 1999 Constitution is self-executory, whereas there's still a matter at the Court of Appeal that has not yet been determined. Secondly, the governor of Rivers State has taken the step of moving the State House of Assembly to Government House as the new location. And of course, the movement is with regard to his own faction of the Government House. And then, of course, a Rivers State High Court has given a ruling that the 27 members who defected to the PDP are not validly elected, legitimate, constitutionally valid members of the House of Assembly. If you could just help us untangle some of these legal issues at the heart of the crisis in Rivers State.
Thank you very much, Doctor. The crisis in the state of Rivers is one that is becoming quite disturbing to all lovers of democracy. And it is unfortunate that when we felt that probably the gladiators were trying to resolve the issues and shedding their swords, we discovered that it is like what Yoruba call Egbiri Ote, that is an insurmountable crisis that is always reproducing itself like the proverbial phoenix whenever people feel that it is dying out. The Constitution is very clear on the position if a member of the House of Reps or House of Assembly, legislator, simply say that, having defected to another political party different from the one on which he was elected, whether he could still keep the seat on which he was actually elected. The Court of Appeal and the Supreme Court have pronounced on the provisions of the Constitution with relation to Section 109 to the effect that where a member of the Legislative House becomes to another political party, he automatically loses his seat. In this situation, no matter how many they could be, whether they are the complete members of the House or just a few of them, the implication is that they have automatically lost their seats. It's unfortunate that the beneficiary of this bad situation is my own political party. Why politically it is a gain to us. Legally and constitutionally, it is a disservice to democracy and developmental politics in any part of the world for a member of the legislative house in a particular country or state to decamp from the party on which he was elected to another party while still serving in the House of Assembly. Having made this clear by the decisions of the Supreme Court on the impossibility of keeping the seat, the implication is that the 23 members have forfeited their seats. Any other interpretation that goes contrary to the decisions of the Supreme Court and the Court of Appeal will be an aberration. We must be loyal only to the Constitution. Yes, while we must maintain loyalty to our political parties and support what will bring progress to our political parties, we must not use the loyalty to our party to defeat the Constitution. Ultimately, if the Constitution is defeated and Nigeria is disintegrated, there is no way we can have a political party that will still be functioning. And I think that is one thing that all the gladiators must realize in this situation. There is no other interpretation we can give to it. However, on the other hand, the decision or step taken by the governor of Rivers State, His Excellency Fubara, by taking the House of Assembly, the seat of the House of Assembly to the government house may be said to be unprecedented because there is a particular structure, there is a place that is built for the House of Assembly to sit. The House of Assembly cannot sit in any other place as decided by the Supreme Court in the case of Kojo and Adegoke, bordering on the removal, the purported removal of Governor Rashidi Ladoja in Oyo State in 2005. To that extent, the implication is that it is not possible for the House to sit in a place otherwise than where the law has built for it. If the members of the House of Assembly that have defected are regarded as having forfeited their seats, there is no way they can continue parading themselves. And that is where I am going to align myself with the decision of the Rivers State High Court declaring that they could not continue parading themselves as members of the House of Assembly. Whereof there is an appeal pending on the issue. The implication is that all parties are supposed to maintain the status quo. The implication is that the members of the House of Assembly who are there right now cannot do anything that would thwart the proceedings going on in the Court of Appeal. The same thing forbids Governor Fubara from doing anything to thwart the proceedings. Rather, it will be better for all parties to work in the interest of the people of Rivers State, in the interest of the Constitution, in the interest of Nigeria, because where a state is in crisis and public order is about breaking down, then the whole of Nigeria will equally be affected. No matter how much we want to pretend that it is in Rivers, it can happen in any other place. So constitutionally, it is not right for those members of the House of Assembly. I was thinking that they probably will go back to PDP as it was purportedly resolved that they should go back to PDP, where they will be able to effectively occupy the seats as members of the House of Assembly of Rivers State. Probably at the level of PDP, they know that it will be impossible to impeach the governor, and that may probably determine the reason why they have decided to maintain their new found love for APC, that they did not contest on its platform, that they did not campaign on its platform, that they did not buy its nomination form to campaign or contest the election to the House of Assembly. It is rather very, very sad and saddening too that this development is truncating constitutional democracy in Nigeria.
All right. Thank you so much, Mr. Adegoke. Let's talk about another development following that ruling. The governor of Rivers State, Simlaye Fubara, has also issued an executive order 012/2023 to relocate temporarily the Rivers House Assembly sitting to the government house. Now, according to, I just want you to clarify something really quickly. According to his Commissioner for Information, he said that the governor has a right to do this, whilst the APC is saying that it is not constitutional. While I understand the developments that have gone on, so far in terms of the ruling of the High Court and the tussle in River State, how do you think this speaks in terms of the constitutional, how constitutional, let me put it that way, is this move by the governor? Because this is, of course, making headlines. We're talking about this morning. But I'd like to get your thoughts on this one this morning.
The move by the governor is one that I would say is simply political but completely unconstitutional. Assuming we have not had the benefits of a judicial pronouncement on a similar issue or on a similar situation, we might be bantering or exchanging pleasantries on whether it is constitutional or otherwise. But we have had the benefit of a decision of the Supreme Court where the apex court, the highest court of the land, that is the only court from which there is no further appeal, has pronounced in the case of Kojo and Adegoke to the effect that it is not constitutional for the House of Assembly to sit in a place other than the building where the law has prescribed that it to be sitting. The House of Assembly is an institution. The building in which it is supposed to be sitting or in which it is sitting is an institution on its own too. To that extent, we cannot divorce the House of Assembly from where the law has built that it should be sitting. We cannot take away the mace and say the House of Assembly is still operating as a constitutional and legitimate institution. To that extent, the governor will be herring egregiously by taking the seat of the House of Assembly to the government house. What exactly does he want to achieve by this? To make sure that the three members loyal to him will be able to sit in a place that he has provided for them, because it might be impossible for them to continue sitting in the place designated for the House of Assembly as the house where it's supposed to be transacting the legislative business. In that regard, we have found ourselves in a situation where one illegality is begetting another illegality. And that is why it is completely unsavory for any member of the House of Assembly or any member of the executive, whether the highest occupier of the occupier of the highest office in the state or even in the federation, to allow illegality to rear its ugly head. The implication will be that what will follow thereafter will be another unconstitutional move, will be another illegality. And to that extent, it will be wrong for the governor to take such a step. I don't know whether he supported or he took the step by which the judiciary, the River State judiciary, declared the seats of the 27 members as having been vacant, and restraining them from conducting any legislative business or parading themselves as members of the House of Assembly until the determination of the suit. If he was party to retain, it means that he has secured a temporary victory. And the implication is that insofar as they have been restrained by the court has the judicial say in any issue, in any matter submitted to it. Okay. The matter having been submitted to the court having issued a restraining order, nobody, no matter how high, not even the president, has the audacity, the temerity, the effrontery to flout the decision of the court. It is a decision of the court by virtue of the Constitution, and everybody, every institution has the obligation to obey that order. Okay. I will not support any institution, anybody, to flout a court order. Okay. If the order is found to be bad, then the party affected should go back to the same court to vacate the order, or that there should be an immediate appeal against it. I am sure that there will be a motion of notice to determine whether those members have the right to continue parading themselves or otherwise. That can be fast-tracked as to determine that issue, and if the court refuses the application for motion of notice, then the members can go back and be performing their duties. That is the position.
Thank you so much, Senior Advocate. But what's your reaction to a country where the president starts the illegality in a deal he made between the parties by saying that illegality of House of Assembly members that defected should keep their seats? I mean, what would you say about the president of a country starting the chain of illegality?
Right. The road to hell, they say, is paved with good intentions. No matter how good the intention of Mr. President may be, I believe that it is a political wrong. It's a constitutional error for the president to have decreed that the members that have vacated their seats should continue occupying the seats. Why I'm saying this is on the authority of the decisions of the Supreme Court that have held that when members defected from the House, in the House, from the political platform on which they were elected to another political party on which platform they did not contest the election, they have automatically forfeited their seats. However, the president, as somebody that quote and unquote I would say is the father of the nation, ought to take a step towards resolving the crisis. There are two ways the president can do this. One is friendly, the other one is unfriendly. Let me put it in that term. The one that is friendly is for him to seek to resolve the crisis as between the two parties, where the resolution will enable the members that have defected, where the resolution, the political resolution, let me be clear about that, where the political resolution as proposed by the president, as purportedly accepted by the two gladiators, who amount to flouting the position of the law, who amount to treating the Constitution with disrespect, insofar as the Constitution has been interpreted by the highest court of the land, then it will be an error for the president to say members who have defected to APC should go back and continue occupying their seats. If they are going to go back to continue occupying their seats, they have to renounce the campaign that they have done, the cross-carpeting that they have done. They have to drop that particular step that they have taken, because that step is said to be unconstitutional. They can only be said to be entitled to continue occupying their seats if they resume their membership of PDP on which platform they were elected, on which platform they contested the election. They cannot ride on the back of a donkey and now kill the donkey in order to make a sacrifice to a horse, in order to make a sacrifice to have a horse.
Okay.
It is not possible. That is the wisdom that informed the drafters of the Constitution when they said you cannot defect from a political party and still keep your seat.
But the presidency is now saying,
yes, sir,
after setting the path of, total disrespect for constitutional provisions, the presidency is now saying, I will not meddle into the matter after they had scattered the matter in the first place. What do you say to that?
Well, I may not be able to actually agree that it scattered the situation. The situation was already scattered before it was taken to the president in the first place. The two gladiators fighting are people who have occupied the highest seats in Rivers State at one time or the other. And to that extent, there is a limit of sovereignty. There is a measure of sovereignty enjoyed by each unit, each federating unit in Nigeria. Rivers State is not less, the government of Rivers State is not a junior, is not a younger brother to the presidency occupied by President Ahmed Bola Tinubu or any other person at any point in time. It is a federating unit without which there will be no Nigeria. There will be no Nigeria for President Bola Tinubu to preside over if a state is taken out today, because the Constitution says we have 36 federating states and the Federal Capital Territory, Abuja. To that extent, the intervention made by the president, and that's initially, and that is why I said that the road to hell is said to be paved with good intentions. Even if the president had a good intention, the outcome of it at the end of the day almost burnt the fingers of the president, because we discovered a situation where people who were not agreeable to the agreement drafted at the presidency, and the two parties were said to have signed, were condemning the president for his mode of intervention. And to that extent, the elders of Rivers felt that if not for the president, His Excellency Siminalayi Fubara wouldn't have agreed to that kind of agreement. And if that should be the case, the president must be careful. He must be very careful if there is any constitutional crisis in Rivers State or in any other state of the federation. The limit of his intervention must be within the ambit of the Constitution. He cannot make one party to submit to the other in a manner that would defeat the essence of the Constitution. His Excellency Nyesom Wike is no longer the governor of Rivers State. Rivers must be allowed to run its affairs. And that is one piece of advice that I have for my learned colleague, His Excellency Wike, that in this instance, it would be better to allow Rivers to run its business. However, what the president is saying right now is for the presidency not to commit another error. And to that extent, things must be allowed to play out in Rivers State. Although, if it gets to a point where public order, where public security and public safety will completely break down under Section 305, we almost realize that the president has the power to declare a state of emergency.
If I may come in here, what the presidency said initially was that they adopted a political solution. And we condemned it at the time, that the president of Nigeria cannot act as a headmaster over the federating units. This time around, we have been told by the presidency that the presidency will not take sides. I agree with you. It's good to allow the people of Rivers State to sink or swim with their own issues. If they want to disrupt the national order, then of course, the country will know what to do. The National Assembly will know how to step in. However, I take your point about the location of the State House of Assembly, that the State House of Assembly has a place of work. It cannot be sitting all over the place. Tomorrow they will say they are sitting in a market. Next tomorrow they are in legislative quarters. Next tomorrow they are in government house. That point is very valid. But I ask you a question, whether it's self-executory that if you move from one political party to the other, then you have lost your position. Consistently in your submission, you seem to hold that it's automatic. But I refer you to Federal Adegoke versus Ondo State House of Assembly, where their lordships,
State House of Assembly,
yes, at the Supreme Court decided the ratio in that matter was Section 109(1)(g) of the Constitution, where they said division is not as you pronounce it. Then it must be of a nature that there is a problem within a party and that party can no longer function. Okay? So the question then was, Adegoke, the appellant at the Supreme Court level, lost the case. Is it the same situation in Rivers State? Is there any decision that we have at hand, apart from the Rivers State High Court decision that you say you have you support? Is there a decision at a higher level? Because the same matter is at the Court of Appeal, and the Court of Appeal has not yet pronounced on the Rivers State case. Are the facts of the case in Adegoke case the same as in Rivers? And then the elders, you also mentioned them, who took the matter to the Court of Appeal. Do they have a locus in this matter? Because I asked Chief Sarab Anasibi when he came on this program, that shouldn't it be the governor going to court? The governor is not going to court. He's taking his own decisions. Do the elders of Rivers State, do they have a locus? Will their matter at the Court of Appeal stand? These are some of the legal issues involved.
Thank you, Doctor. I appreciate the angle from which you are coming. In actual fact, when referring to the decision of the Supreme Court, it was specific reference to Adegoke and the Ondo State House of Assembly. In Adegoke, you recall that the Supreme Court was quite emphatic as regards a situation that will enable a member of the Legislative House to decamp from one political party on which he was elected to another and still keep his seat. That is where there is a division at the level, at the national level of the party, that the party has become so fragmented that it cannot continue functioning as a political party strictly so called by the Constitution, under Section 222 of the Constitution. However, in Adegoke, which is quite, the facts of which are quite on all fours with the present situation, we are not aware of a division in the People's Democratic Party at the national level where the party is no longer able to function. We are not aware of maybe a contender to the national seat, to the national chairmanship seat of PDP, where the party has become so divided that it cannot be regarded as a single institution anymore. And that was the situation in Adegoke when he decamped from his political party to another. And now that we have a precedent, all lawyers know that where there is a precedent, the essence of precedent is to guide similar situations as may occur in future. Every case that comes before the court has a predecessor in precedent. Every case has a father decided that has paved the way on how it is going to be decided. Where there is no precedent, in which case the court may have to look at the provision of the law or look at the facts and now make an interpretation and make a decision. Such a situation is going to be a locus classicus on its own. However, we have the benefit of Adegoke and those state house of assembly. There is another matter at the level of the, maybe I think in Imo or Anambra states, in which the Court of Appeal equally any member of the House that defects to another political party has lost his seat. If we have these precedents already pronounced by the higher courts of the land and the highest court of the land, then there is no need to be looking for another interpretation when a similar situation has presented itself. Every gladiator in a political disagreement will want to say that decision will not bind me. We will be looking for something to distinguish it. Yes, it is necessary that parties must submit their dispute at the level of the Court of Appeal, as it is right now, is good for the parties. That is what I said earlier, that it will be good for the parties to share their thoughts and allow the Court of Appeal to make a pronouncement on this issue. And where a party is not satisfied, the Court of Appeal is not the highest court on this matter. The party that is disagreeable to the decision can as well go to the Supreme Court. However, when you look at the present situation, and I've not been able to make any distinction, or any distinction that we seek to make, any difference with distinction we try to make will be without a difference. In this situation, the situation in Rivers is not too far away from the case of Adegoke and those state house of assembly, and that is why that case to govern the present situation. The elders of Rivers who have taken it upon themselves to challenge the constitutionality or otherwise of the issue. Yes, we have raised whether they have locus to do so. Yes, locus, according to law, is the standing to sue, the ability to be able to make a case before a court and have the legitimate right to.
Right. Mr. Adegoke?
Then the court has no jurisdiction in the first place.
All right.
And when you look at the parties that are involved, the court, they are not the House of Assembly members. The House of Assembly members, either as a whole or as a part, or even an individual, will have locus to approach the court. The governor will have locus to approach the court. But elders of Rivers State, whatever name they call themselves, even if they say they are suing for and on behalf of generations yet unborn in Rivers, that will not confer locus on them to be able to approach. The matter, whether they have locus or insofar as the Court of Appeal has not pronounced on it, the matter is still live. The issue is still live before the Court of Appeal.
All right.
The parties should allow the Court of Appeal to. Who can tell? Because the law is very dynamic. We may at the end of the day discover that they even have locus. We are only using the present interpretation of what we are familiar with to determine a case that is yet to be pronounced by the court. And if the parties know that they have no locus, they wouldn't have approached. If they agree that they have no locus, their lawyers wouldn't have approached the Court of Appeal. So it's on this basis that I would say that the best in the situation.
Except that many lawyers leave the law and they focus on their pay. I mean, we've seen many lawyers taking frivolous cases before the court.
Well, Mr. Adegoke, we're so grateful for your time.